Hello and welcome to the webinar, The Legality of eSignatures, All Your Questions Answered. It is impossible to deny the challenges brought by the current COVID pandemic has pushed legal transformation to the top of many organizations' agenda. Over the past year, every company has been seeking new ways to improve business continuity through digital solutions. When it comes to document control processes, electronic signatures have been identified as a viable way to optimize contract workflows, improve productivity in remote work environments. Yet, more often than not, there are still many questions surrounding the legality of electronic signatures. Are they legally binding? Will they hold up in court? Are they secure? Well, in today's session, we will answer all your questions around the legality of electronic signatures. Specifically, we'll discuss what exactly e-signatures are and where can they be used, the legal validity and security of electronic agreements, and the electronic identification, authentication, and trust services regulation, and how it is incorporated into local legislation. My name is Haveen, and I'm one of the editors here at the Legal 500. I would now like to warmly welcome our expert panel, who as industry leaders will be sharing their valuable insight with us today. In no particular order, we have Hugo van Vil, legal counsel within the retail practice group at Delhaize, Belgium. Hugo began his career in private practice before making the leap into in-house in 2004, where he took up a legal counsel role at Total Belgium. Whilst at Total, Hugo worked in both Belgium and France in a range of legal positions. On the 1st of January 2020, Hugo joined the legal department of Delhaize, Belgium, becoming its legal manager retail. In this position, Hugo has been responsible for the rollout of DocuSign, a software tool allowing the electronic signature of documents by any person with a valid email. And he also oversees the implementation of the guidelines for electronic signatures at Delhaize. Having worked so closely with e-signature technology, we are really lucky to have Hugo on the panel today. Welcome, Hugo.
Thank you, Harveen. I'm very happy to be here. Welcome, all of you.
Also joining us today is Berdan van de Eek, counsel at Bird & Bird. In this role, he works within the Amsterdam-based international data protection and commercial practices of the firm. He advises on global domestic data compliance projects, technology contracts, data protection enforcement, and the legal aspects around online innovation and advanced technologies. In addition to this, over the years, he has been seconded to a number of technology companies, including a prominent telecom operator, a leading automotive company, and a pharmaceutical company. With such a heavy workload, Berdan still finds time to co-edit the Journal for Internet Law. He's also a published author, having co-written a number of books on law and computer games and on the liability of intermediaries. Lovely to have you here with us today.
Thank you, Arveen, and nice to be here. Looking forward to the session.
On the panel today, we have Denise Fitzgerald, Senior Sales Manager at DocuSign. For those who don't know, DocuSign is a company that was created in 2003 with a mission of accelerating business and simplifying life for organizations around the world. Since then, it has been on the forefront of e-signature technology. Denise has been working at DocuSign for over 2 years, and before that, she spent a number of years in the information technology and services industry. Welcome, Denise. Thank you for joining us.
Thank you, Harveen. Thank you for the invitation, and lovely to be here.
Before I hand over to Denise to get the session started, I just wanted to remind the audience, if you have any questions throughout, feel free to leave them in our Q&A chat boxes, which you should be able to find somewhere on your screen. Our panelists will be able to view them in real time. Okay, with that being said, I will now hand over to Denise, who will give an introduction on e-signatures. Thank you, Denise.
Thank you, Harveen. Thank you, Harveen. Right. If you could move on the slides, please.
Oh, absolutely.
Good morning, everyone. So it is our belief that every company has what we call a system of agreement. And this is where we look at what happens before and after an agreement gets signed. So this slide depicts it very well, and this is what we call a system of agreement. It's how agreements get prepared, then they go for signature, and then once an agreement comes back signed, there are obligations within that agreement that have to be fulfilled. Once those obligations get fulfilled, the agreement somehow has to be managed and it has to be stored. Now, the challenge that we find when we work with our customers is that their system of agreement is very manual and it's very paper-based. So it's just not built for the speed of today's business. So what is critical is that this system of agreement is modernized. And it's hugely important because agreements are everywhere and businesses run on agreements. They span the entire organization from front office right through to back office. If you could move on to the next slide, thank you. And that is why DocuSign has built the DocuSign Agreement Cloud. We help our customers connect and automate the entire agreement process. Before we jump into electronic signature, I want to take the time to explain how DocuSign ID verification works. Now, as you know, identification varies by country. So what we'll do is we'll ask the signer to verify their ID. And depending on the ID issuing country, the signer will be presented with that option. In most countries, signers can use their driving license or their passport. In other countries like Scandinavia and particularly Netherlands, identification can be verified by the existing online eID credentials. In Sweden and Norway, you've got Bank ID. In Denmark, you have NEM ID. And in Netherlands, you have IDIN. In other countries, smart identification cards are used. It's also worth noting that ID verification also works with our digital signature offerings. And that will, by adding it to our digital signature offering, it will provide an advanced signature level. So what DocuSign ID verification does, it removes the complexity. It's a one-stop shop. It's a solution that has the technology across every type of identification. So are eSignatures and ID verification safe and legally valid? In short, yes. Agreements can be legally signed all over the world. From an EU perspective, eIDAS is the EU directive that was effective in 2016. And what this has done, it has paved and continues to pave the way for a uniform e-signature market in the EU. What it did was it mandated the adoption of electronic and digital signatures by all states. It also defined, validated, and accepts the 3 different types of signatures, which are standard, advanced, and e-signature, which ultimately makes it easier for cross-border transactions. Now we have 3 types of e-signature. The first type is the standard e-signature. It's the most basic signature. It's most commonly used. There's no signer ID verification required. It's similar to a signature on paper, only that everything is done digitally, and there is also an audit trail provided. The next type of signature is an advanced electronic signature. It's equal to, it's also known as a digital signature. And this is used to establish the identification of the signer by means of SMS authentication. Now, the highest and most secure type of signature is the qualified electronic signature. It is a signature with a qualified certificate that is issued by special authorities. It's legally valid and it's legally equivalent to a wet signature. And the difference with this particular signature is the burden of proof lies with the signer. And before I hand the floor over to our fireside chat, I want to leave you with this visual of how you compare a wet signature, so a signature on paper, to electronic signature. And you can see here from the electronic signature, which this is their certificate of completion, all of the information that is captured. So you can see the signature, you can see the timestamp, you can see the IP address, and you can also see the email address. So I'm just going to leave that with you for a second or two, some food for thought for sure.
Okay, thank you, Denise. Thank you for that introduction and taking us through eSignatures. Now it's our time, fireside chat. For our audience members currently, this is a great time to send in your questions. But we will begin by going through some of the most pertinent questions that often come up. Why do we use signatures in the first place? I might let Berdan lead with this one.
Thanks, Arvine. Indeed, it's a very valid question because signatures are very often used with agreements, and we conclude agreements throughout the day, and you barely notice it. When you buy bread, a bottle of water, ice cream in a park, you conclude agreements, but you don't usually sign an agreement. You might not even speak a full sentence. This starts to differ when you sell something on eBay, for example. There is at least a written component, but you don't typically sign. It could change, however, as the value of the goods increase. If you buy a car, for example, you might want to have some evidence of the purchase of the car. And that's starting to show what the purpose is of signatures and agreements. It provides evidence of the agreement and of the party agreeing to it. So in many countries, such as the Netherlands, a signed agreement or a deed has a strong evidence position. In the Netherlands, it's called compelling evidence. So if you claim forgery of the document, you will have the burden of proof, and that, of course, will provide you with a strong legal position.
Okay, well, let's have a look at the legality of e-signatures in Benelux. Hugo, would you like to start with this?
Yes, of course, Harveen. Maybe we can move to the next slide. And in short, I would say my message is double. First of all, almost all documents can be legally signed using an electronic signature. There are few exceptions of types of documents which cannot be signed using an e-signature. For example, certain real estate rights need to be signed using a handwritten, a manual signature. Contracts requiring by law involvement of courts, public authorities, etc., need to be signed manually. Certain contracts of suretyships and contracts governed by family law. So there are a few exceptions, but few of them really are pertinent for the business. And I would say all general business contracts can be legally signed using an e-signature instead of a manual signature. So that's the first message. Second message, as Denise showed, in Europe, we distinguish 3 different types of e-signatures. You have the standard, the advanced, and the qualified legal signature. according to Belgium and Luxembourg law, and I'm assuming the same goes for the Netherlands, these three types of legal signatures are all legally valid. So the validity of the signatures is there. No worries. Each type of legal of e-signature is legally valid. But only the third type of e-signature, the qualified e-signature, will have the same evidential value as a handwritten signature. And so the difference in the three types of e-signature is not in the validity, but it's in the evidential value. Does the signature, the e-signature, prove that the person who put the e-signature is actually has the identity of the person that was intended to put the signature? So as in the past with manual signatures could be forged and counterfeited. E-signatures also need to be proven to be placed by the person that put the e-signature, and only the qualified e-signature gives a full proof of the fact that that person is actually the person that signed with an e-signature. Nevertheless, also the standard and the advanced legal signatures, e-signature, are legally valid, and they offer for the standard e-signature the lowest evidential value. For the advanced e-signature, there is more evidential value that the person who put the e-signature is actually the person behind, that it's there is the actual person behind this is linked to that e-signature by having the two-factor authentication that Denise talked about. So that's actually the difference, and that's the main message that I wanted to share with you guys. In terms of validity, they are all the same. In terms of evidential value, they go from standard to advanced to qualified, which is the only e-signature that is similar in evidential value to a handwritten signature. So I hope that's clear. So back to you, Harvey.
Thank you, Hugo. I think covering Belgium and Luxembourg, Verdun perhaps can also give his views on this question.
Yeah, sure. And in the Netherlands, it's quite similar, which is good for a European regulation. What is harmonized across Europe is indeed, as Hugo said, the qualified electronic signature. So that's all the same across Europe, and there are some nuances and differences when it comes to especially regular electronic signatures, and advanced are also provided for in the regulation, where there's a component that needs to be implemented by local law. So you can see some nuance differences there. For the three signatures, also in the Netherlands, they can all three be of similar value as a wet signature. The thresholds or the requirements in the Netherlands for an electronic signature to be the same as a wet signature is that the signature methods, for example, DocuSign, is sufficiently reliable, looking at the purpose for which you use the electronic signature, and this is very Dutch, all other circumstances of the case. To provide an example of the latter, if the value of a contract is very high, parties have never met, and you have maybe other indicators that you want to or you need to further verify the identity of the signatories, that might be a moment where you think, wait, this is not suitable for a standard electronic signature. In this case, you might want to consider the qualified electronic signature or the advanced electronic signature. So, like I said, this is quite regular under Dutch law. We use open norms that will provide courts with flexibility to decide on whether a agreement is signed in a particular case.
Okay, I think this links nicely. Both of you sort of touched on it a bit, but when does e-signature have the same worth as a wet signature?
Shall I kick off?
Yes, please.
Since I'm already speaking. No, that's indeed in the Netherlands at least, and I think perhaps also in Belgium. It depends on the circumstances of the case mostly. If there are indicators that you need to have further safeguards, then in that case it could be that if the contract value is very high, parties have never met, then there is a higher standard for the electronic signatures required. It could still be a regular electronic signature, but the court will scrutinize the method that you use. So it depends in that sense on the circumstances. Of course, maybe I should add that most of the times there isn't a dispute about the existence of an agreement. Parties will conclude the agreement and then start paying and executing the agreement. And that's, of course, one of the reasons why in practice there's not a lot of discussion. I did some research on this. There's not a lot of discussion on the signatures itself. The discussion is usually about the content of the agreement. And Hugo, this is, I think, also something that you can relate to in practice.
Indeed, Berend, I fully agree with what you said. First of all, in terms of practice, it is, I would say, normal human behavior that for contracts with a higher contract value, you would perhaps prefer either a manual signature or a qualified electronic signature because of the importance of the contract. Whereas for lower contract values, you might easier be inclined to use an advanced or a standard electronic signature. So that's definitely a consideration that is in the mind of people. But I would say it's also a matter of cold water fear or cold feet, or how do you call that in English? It's electronic signatures are new. And so people are sometimes a bit reluctant and afraid to use them. And I would say there's no need for that. There's no worry in terms of validity of the e-signatures. There's there's a firm legal framework, at least in Europe. So no worries there. So it's in fact a practice, and it's a shifting in the minds of people that use an electronic signature. And I've seen the same in courts when I started as a legal counsel and as a lawyer before that 25 years ago. Emails were still very uncommon. And so using an email in court as evidence was not something which had a lot of value. Whereas nowadays, 25 years later, even courts have gotten used to the existence of emails, and the same will happen with electronic signatures. So it's also a matter of society evolving and courts, the law evolving with it.
Hugo, if I could just add to that as well, using electronic signatures is a fast, it's easy and secure way to sign agreements that are legally enforceable. What we're seeing as a result of COVID, as a result of the pandemic, and where remote working has become the norm, we're seeing that the adoption of electronic signature has been fast forward by 3 to 5 years, as companies businesses now realize that they need to transform how they do business digitally. So that's the whole pandemic is really driving that adoption, and we can really see it in our business today.
Yeah, I fully agree with you, Denise. A lot of things which we thought were impossible 1 year ago are common practice today. And you need to adapt because the business continues. Contracts need to be signed somehow. People can't go to the office in order to get a document signed by people who live, well, Belgium is a small country, but it's just not practical. So the e-signatures offer a perfectly practical solution for a very real problem today for the businesses.
Yeah, very true.
I think this links nicely to the next question, which is why would you use DocuSign? Perhaps, Hugo, you want to start with this? I know that you've had experience leading it in your organization.
Well, indeed, at the Laser, we implemented DocuSign, but what I can say about DocuSign can also be said about, I'm sure, about other types of e-signature providers. So I think it's a matter of, I would say, informing yourself and making a decision, and there are multiple solutions out there, I guess. Why did we like DocuSign? First of all, of course, because it's an international platform, and Ahold Delhaize is an international group, and so it is easier to implement an IT tool throughout an entire international organization, rather than using different types of providers for the same IT issue. DocuSign offers the full palette of e-signatures, the standard, the advanced, and the qualified, which is important because, as Berend also explained, depending on circumstances, you might want to use one rather than the other type of e-signature. What was important for me was the ease of use. We've had, when we implemented DocuSign, we've had a trial period, sort of a pilot, where we got very positive feedback of the users. I use it myself, and I'm not a digital savvy, whatever, so it works and it can be done. And what was important for me is that when the COVID crisis struck, as business needed to continue, you saw all kinds of solutions pop up on people copying their signature and pasting it into a document, etc., etc. And so having an organized, uniform system of e-signature throughout your company, I think that's very valuable. Yeah, we've discussed the practical issues of home working and signatures. And maybe another thing which I liked about DocuSign, but I guess the same thing can be said about other solutions, is the possibility to plug it into existing contract management systems or solutions, which allow you to manage your entire contract basis, and including also the signature using DocuSign, and then up to archiving, etc., etc. So various reasons, I would say, to use an e-signature solution in your business.
Denise, do you want to add anything to that?
Yeah, sure. So why would you use DocuSign in this sense? I guess we're number one for electronic and digital signatures. And when we look at the platform itself, it's easy to use, it's intuitive, and it's very secure. It's very secure because we adhere to the most stringent security standards globally. And we have taken a security-first approach to ensuring that our customers' documents, their certificates of completion, their audit trails are all maintained safely and securely before signing, during signing, and after signing. And Hugo mentioned about integrating within the system, within the contract management platform system. We have strategic partnerships with Salesforce, with SAP, with Oracle, NetSuite, and all of the big tech companies. So we can integrate your e-signature within your system of record, albeit on the sales side, your CRM, within legal, your contract management platform, or perhaps on the finance side or HR side through your ERP system. I've talked a little bit about ID verification, a suite of other solutions that we provide, but whilst we're synonymous for e-signature, we go beyond e-signature, and we are really an agreement-led company, and we can help our customers connect and automate the entire agreement process. And I guess finally, and this is where I get the most satisfaction from my job, it is really over half of our workforce is dedicated to customer success. And that's what makes us successful, because we invest in our customers. And the real sense of achievement is working with a customer and seeing them start on their digital journey and starting that journey and knowing that they've selected us as their partner of choice to also help them scale up into the future. And I really, I guess that's key to DocuSign is we're here to ensure that our customers are successful and they adopt correctly.
Okay, well, we've discussed the why. How is also another part of that. Hugo, I'll let you lead this one, which is, how have you implemented DocuSign?
Yeah, I guess, well, but when we started, first of all, we signed a contract with DocuSign, and in fact, I do not know whether we signed it digitally or manually, Denise, because it was signed at group level. But first of all, we did a pilot project. We identified 3 departments within the Deleuze organization to roll out DocuSign within these 3 departments. So with a limited number of users, we could control the use of the tool, how it was done, etc. We chose the legal department, the IT department, and the real estate department. The rollout was done during 3 months. Users were very positive when giving the feedback, so we did an evaluation after 3 months. Takeaway was very positive. And actually, for me, it was useful to do this rollout in 2 phases. Based on the positive evaluation, we then rolled out DocuSign for the entire Deleuze organization. During the pilot project, we could provide, with a limited number of users, we could provide training, which we later used in the entire organization. We had a time to establish guidelines for electronic signature, which we could fine-tune with the lessons learned from the pilot project, and then hand over to the entire organization. So that was a good way to implement, I believe. And there was an interesting feedback. A lot of users said very easy to use, the tool, very practical, 100% positive feedback. But if there was one comment, it was on we had foreseen the use of an advanced electronic signature. We obliged that during the pilot phase. And multiple users told us, well, it is a bit unpractical, that because of the 2-factor authentication, you also need not only a valid email address, but also a valid mobile phone number in order to do a second check on the identity of the signee. And based on, I would say, and remember what I said about having cold feet at the start. We changed, in fact, our practice, and we, when we rolled out the DocuSign tool for the entire organization, we changed from the advanced electronic signature to the standard electronic signature. So we allowed our business to validly sign the contracts using the standard electronic signature, which is the signature with the lowest evidential value. But at the same time, and that was a risk assessment that we took as a business, as a company, which I took also, or I confirmed as a legal counsel of Deleuze, based on the fact, as Berend said, that there is very little jurisprudence, in fact, with companies questioning the validity of and the identity of the person that signed an agreement, and based on the fact that the business practice is in our company a lot of recurrent business. The best way to prove an agreement on a contract is that the contract is performed. So in a recurrent business, well, it's easier to demonstrate that there was indeed an agreement between the parties. And when at a certain moment in time the agreement goes sideways and there is a need for legal intervention, at that moment the validity of the legal signature is very rarely put in question. So that's why we made that shift. So, and I was happy, in fact, that the pilot project allowed us to make that evaluation and to make that shift. And I guess it helped the business being more reactive and practical based.
Absolutely. Denise, is there anything you want to add to that, or?
I'm just really happy to hear Hugo's story and you know, the journey that he and his team and the wider company went on. And it's really important, the way Hugo has spoken about is the adoption. And it is change management. You do need to bring people on board. You do need to give them time to get comfortable with. We're changing processes. It's change management is what we're looking at. And I guess key to your success, Hugo, is that you embarked on a pilot, a proof of concept to get people comfortable with the change on in this particular business process. And of course, I'm delighted to hear that you also used our training resources to make sure that you adopted fully, and you're starting to see the success now.
Yeah, exactly, Denise. And you have something at DocuSign which is called the DocuSign University, which is a
Yes.
very, very helpful online platform with many frequently asked questions, a lot of information about e-signatures, how to use DocuSign, etc. So there's a lot of support, and that's very appreciated. And indeed, it's a matter of change management. So you need to accompany your business and if you implement an e-signature tool, do it the right way and accompany the business, and they will appreciate that.
Yes, it's hugely important, and that's where we see success. We see huge success when customers lean into us to help with that onboarding, with that enablement and that adoption. And of course, we're more than happy to support in this particular area as well.
Okay, brilliant. I can see the questions trickling in. I'm going to actually change the screen back to the panelists. And we'll get some of these answers answered. So I'll just, there we go. So I can see them trickling in our Q&A, and shall we start with?
If I may say, Haveen,
Yep,
during
please.
the chat, I've tried to answer a couple of questions already. There was an interesting question about dual signatures. So somebody asked whether it was possible to have a document validly signed by one party using an e-signature, while the other party or parties sign manually, and that is perfectly possible. It is a bit more, the practicalities are a bit more complicated, but it is perfectly possible to have two parties to an agreement sign, one manually and one electronically. So I thought that was an interesting question. Perhaps there were other questions.
Yeah, I've already identified, I would say, the mother of all questions when it comes to electronic signatures, and that's about the simple scanned signature, which is something that you see still quite frequently. And there the question is it also fully valid? In my 10 years working in law practice, as Arvin mentioned, I've also been seconded to various companies, and there I've also seen, for example, people working in the Microsoft Word and then signing agreements with just copy pasting an electronic signature, or at least a digitalized version of their signature. If you hold it to the standards of Dutch law, it would not be a valid electronic signature, so it would not have the same evidence typically as a wet signature. And the reason is that it is considered not sufficiently reliable, because, well, I can scan Hugo's signature and I can start using it and sign documents on his behalf, and there's very little way to verify that it was me, or actually to verify that it was Hugo. And and not me. So that goes to show that you need to have a reliable method to link the person signing the agreement with the signature, and that's basically the key of electronic signatures. And all the three different signatures provide additional means, additional safeguards to link the identity of the person signing the agreement to the digital signature. So I hope that answers the question. It's not. Maybe I should add to that is that it could still be an agreement, so you would still have some form of evidence, but the evidence is just not very strong if somebody else can copy paste your signature. But the moment the agreement will be executed, payments are made, deliveries are made, yeah, then you would have a more difficult discussion about the existence of the agreement. But still, it's not as good as evidence as a electronic signature.
And Baron, if I could add to that, when you talk about that evidence, the evidence that you're referring to is a certificate of completion. So with every transaction, with every signature, the platform generates a certificate of completion, which is the audit trail, and it captures the timestamp, it captures the email address and the IP address. And in the unlikely event of a legal dispute, it is admissible in a court of law. Okay.
Thanks.
There was an interesting question about if one company signs in Indonesia and another company signs in Switzerland, what happens or how do we determine the validity of the e-signature? And I would say it depends on the law of the contract. If the contract is based on Belgian law, then the validity of the signatures of that contract will be governed also by Belgian law. So it depends really on the law of the contract, whether the contract can be legally and validly signed using one type of e-signature or another. So I thought that was an interesting question as well.
Yeah, and of course, the fundamental issue here will be that a court receiving the documents, the contract, the evidence, and the claim will first need to look at whether or not a contract has been established. So it's a chicken and egg problem, if you will, where maybe an Indonesian court would apply its local rules regarding signatures, then finding out that applicable law is Belgian law and refers it back to Belgian, and forum is the Belgian courts, and it would refer it back to Belgium. So I think that highlights the fact that if you are going for digital signatures, it's best to use a provider of digital signatures that is known around the world, because most likely DocuSign or Adobe or other digital signature providers will provide their services in many different countries, and that helps because in those countries there will be hopefully also case law regarding those specific service providers. So you have more certainty, whereas you would use only a local Dutch electronic signature provider.
Yes, and what DocuSign has done, because a lot of our customers have an international presence, what we've done is we've done quite extensive research in when we look at national laws worldwide, and we've put together a legality guide which just calls out the different national laws on a country by country basis. It's really just to help our customers to have an international presence, to take that burden away from them, or that complexity, so that they know that when they work with DocuSign that we comply with all national laws worldwide. And it is just a guide.
Great. I can see we have loads of questions. I'm happy to pick them at random, or if there's ones that resonate with the experts on the panel, feel free to jump in and point them out. Otherwise, I'll I'll start working our way through them. So a question that's been written is, how do you keep track of who signs with different departments if the final version of the agreement is signed? Can this be controlled by the legal department? This might be a good one for Hugo, seeing he's actually using it within his team.
Can you repeat the question, Haveen? I'm sorry, but I was reading another question in the Q&A. Really sorry.
That's okay. Yes, I definitely, there are heaps of questions, which is always great to see. I'd be happy to read it again. The question was, how do you keep track of who signs what within the departments? Plus, if the final version of agreement is signed, can this be controlled by the legal department? Yeah,
very, very good question. And there's multiple issues there. First of all, we have a policy, of course, in the lezer identifying who can sign, who has the authority, the power to sign and to represent the lezer externally. So there is an internal policy that needs to be complied with, and that identifies the persons with authority to sign on behalf of the lezer. And that is independent of any e-signature or manual signature debate. These rules need to be followed and need to be complied with. There is or there was a concern at the lezer, which I compare with the old situation of stamps in an office of an assistant. Anybody with a user account at a DocuSign user account can use this account, log in, and start signing documents, either work related or maybe not work related. So there is a potential, I would say, compliance issue. You need to make sure that people use company resources for company purposes. And that is possible with DocuSign. With the DocuSign tool, you can check what type of documents are signed by what kinds of people. You can archive documents using DocuSign. We don't do that at the lezer. We use a different archiving tool for our contract management. So we use DocuSign for its signature aspects, but not for the archiving. But voila, fine. That's. I hope this answers the question. Go ahead.
We have a question about risk. What about risk that the person that is signing is not the person that signed with the standard signature? Because if you know the email address and the password of another person, they can log in and sign. What is the security on this?
Yeah. It goes back to what Berend said. For example, if somebody copies my signature, scans it, and then uploads it in other documents, there will be, I might be in trouble, but I will be able to prove that the signature, that it was not me. But that is the whole debate. As I said earlier, under Belgian law and under most European legislation, all types of e-signatures are legally valid. However, the evidential value is different, and that's really the thing. The evidential value shows or determines that the person that put the e-signature is really the person that you intend to put that e-signature. So with the standard e-signature, you only have the IP address in the certificate of completion. When you use an advanced electronic signature, the person does not only need to use a specific email address, but also needs to add another layer of authentication by putting a code that is provided on his mobile phone. So that's another security, that the person who signs the document is actually the person that you want to sign. And then with a qualified, there is an even stronger authentication, not only with the IP and with the IP address and with the mobile phone authentication, but also with an electronic ID card control, etc. So different types of e-signatures with different types of protection to ensure that goal of making sure that the person who signs electronically somewhere in at the other end of the world, in Indonesia or in Zimbabwe, that it is indeed that person, and you can bring it back to that IP address, etc., etc. And all that evidence
this actually ties in. Sorry.
No, all that evidence is stored in the certificate of completion, which can be brought before court, and which demonstrates the evidences the identity of the person behind the e-signature. Go ahead, Berend.
Yeah, thanks, Hugo. And indeed, it's as you say, those safeguards will help with the validity, and that ties in with another question from the audience. And the question is: are you aware of any case laws deciding on e-signatures validity and enforcement? I'll repeat that. There is surprisingly little case law around the validity of e-signatures. Yes, throughout the years, here and there, but more than you would expect, considering that agreements are signed every day. But that's usually because the agreement itself is not challenged. But still, there is some case law, and for the Netherlands, we have a case law on what we also just covered. Let's say a copy paste of a e-signature, of a scanned wet signature. The Supreme Court considered that in this case there was not a sufficiently strong link between the signature and the individual that was supposed to have signed the documents. And the Supreme Court referred to the advanced and qualified electronic signatures as ways to further ensure that the signature is in fact the signature from the individual that was supposed to sign it. And this is actually something that you will see in cases in the Netherlands, in particular following that decision, that there were circumstances that made the court doubt whether or not the signing or the signature was linked to the individual that was supposed to sign the agreement or deed. So in Dutch courts, there's quite often a reference made to advanced and qualified electronic signatures. So indeed, using a second means of authentication or verification, like receiving a text message, will provide additional safeguards. And I think choosing a electronic signature provider that provides those three sorts of electronic signatures, not only the standards, but also the advanced, so with a text message, for example, but also the qualified electronic signature, that will provide you with the flexibility of using a more reliable electronic signature in circumstances where you may have doubts whether or not the contracting party is indeed, or the person signing is indeed authorized to sign the agreement. Of course, you also need to check chambers of commerce to see if that person is indeed authorized, but that's important, and also answers another question, which is, how do I choose which electronic signature solution to use? I would strongly recommend choosing a solution that provides those three different types of electronic signatures. And without saying you should use one or the other, I think using a global solution will help you in your day-to-day business, because it gives trust to your counterparty that you're using a solution that they recognize. Otherwise, you will have a hard time explaining a Kenyan e-solution provider or a local Hungarian e-solution provider. Even though they could still provide the same level of trust, it will cause friction in the execution of the agreement.
Thank you. All right. Well,
everybody's browsing through the questions.
I see a question in terms of execution, which one prevails, e-signatures or physical signing? I would say when you talk about a qualified electronic signature, they are both, they have equal evidential value. So that's the difference, I would say. When you talk about a standard or an advanced electronic signature, it would not have the same value, evidential value, as a manual, a wet ink signature. So I hope that is clear. Another question that I saw in the chat doesn't for Belgium, so I take it, Berend. Doesn't the standard electronic signature coupled with written exchanges validating the agreement, for example, emails, give legal force equivalent to the paper signature? I would say, again, there's a difference between legal force validity. The validity is there, but you need to prove that the person who signs the contract is actually the person that has the power to sign. So with a standard electronic signature, the burden of proof would be on the person that wants to demonstrate the validity of the signature. Under Belgian commercial law, the evidence is, the rules of evidence are very free, very broad. Anything can be used as evidence in court in order to prove the existence of a commercial agreement, so including emails. And I would say there's a lot of circumstantial evidence when you have an agreement signed with a standard electronic signature and you have accompanying emails. And then perhaps you have a start of execution, a start of performance, etc. Those are all elements that will count if you need to prove validity of the contracts before the Belgian courts. I don't know, Berend, if you see any other questions, legal.
Yeah, I see one regarding legalization of signatures by the notary, and that's actually something I discussed with our notary as well, because notaries, in my view, deal with stamps, signatures, and ribbons, and that was once again confirmed. A qualified electronic signature, as has been repeated in this session, has the same value as a wet signature. However, a notary will, the function of a notary in many cases is that you provide solid, conclusive evidence of a deed, of a fact, of a transaction. And notaries are still not entirely comfortable departing from the wet signature, because it is part of the trust function that they have in the legal world, in society at large. I would almost say signing something in front of a notary is it's a part of what a notary is. And in addition to that, one notary might be comfortable doing that, the other notary might not be. And in an international context, as we also touched upon, the European qualified electronic signature might not be accepted in Russia. It might not be accepted in Turkey. They may have their own ways of qualified electronic signatures there. So I think a notary, especially a notary, legalization of documents, etc., that is still very much a manual process that requires the right signature at the right place in the right document format with a ribbon. I'm exaggerating a bit, but that is the world of legalizations. I must add, I'm not a notary, but I've had my share of legalizations, both private and in the business context. I hope it answers the question.
Yeah, and also according to Belgian law, Berend, in order to complete what you say, I would say contracts that need to be validated by a notary are excluded from the use of electronic signatures. So you cannot use, unfortunately, an electronic signature. You actually need to appear physically before the notary, and then the notary needs to verify your identity with your ID card and your presence in person, and only then will he be able to complete the document and put whatever the notary does, put all the stamps and finalize the deed.
Okay, I can take the next question. So the question is, we intend to roll out eSignature with global scope. A large part of our contracts are entered into in China and Brazil. What is the status of eSignature arranged via DocuSign in China and in Brazil? So just to echo what Hugo and Berend said earlier, DocuSign has an international presence, and we comply with all national laws worldwide. As I mentioned earlier, we have compiled a legality guide which outlines how we comply with the national laws in both of those jurisdictions. And it's something that I'm happy to follow up with after this call.
I don't know if we still have time, but there's an interesting question on data protection, data privacy. I noticed that the IP address is mentioned in the e-signature. Said data may be considered as personal data. Where would this contract and embedded personal data be stored? And sometimes we need to comply with data localization requirements, and that's indeed a very good point. And actually, there's two comments that I would like to make. First of all, indeed, the IP address could be considered as personal data. Also the telephone number, if you use, for example, a two-factor authentication and you use the mobile phone number of a signee, which is then reproduced and in the certificate of completion, that's another element of personal data. I would say insofar as this document is used for business purposes and stored within the company as any contracts which were manually signed in the past, I don't see a real issue. However, what I wanted to say earlier when we discussed the implementation of DocuSign in the Lease, it was a consideration to move from the advanced electronic signature to the standard electronic signature, because in the standard electronic signature, you don't use two-factor authentication with an additional mobile phone number. And we felt that it is sometimes inopportune to have the mobile phone number, for example, of our CEO mentioned in a certificate of completion that is shared with the other party that also signs this document. You do not necessarily want your CEO's mobile phone number reproduced in certificates of completion, and that was a consideration to use the standard electronic signature instead of the advanced electronic signature. But maybe Denise, you could also add a few words on that.
Yes. I mean, if you look at DocuSign from the perspective of data protection, data privacy is a top priority for us. We are GDPR compliant. We also set out as part of our contract, we have a data processing agreement which sets out how we process that data as the role of a processor. So that forms the basis of our contract with all of our customers as well. And when it comes to data residency from a data center perspective, within Europe itself, we have 3 data centers. So we have Amsterdam, we have Frankfurt, and we have Paris. And we also have one in London as well. All of our data centers are managed and owned by DocuSign as well. We also, when it comes to the data storage, the data will be stored wherever the account resides. And we also give our customers the opportunity to choose which data center they wish to store their data as well.
Yeah, in terms of, I saw a question regarding, and it's linked to data protection, regarding information security. And of course, any online tool or any platform or any tool that you use for electronic signature would need to be vetted by your information security departments, of course, and for DocuSign that was done and completed, and no worries there. But that is part of the process, and you need to make sure upfront before you decide to implement such a tool that in terms of information security, everything is bulletproof.
Sure, Hugo, that is a really important point. In the initial discovery, or when our prospects are evaluating us as a vendor of choice, we will always ask, please, who's your security team? Who's your security person in your organization? Somebody within your organization is going to want to speak to us about the security and the integrity of the platform. And it's something that we will drive the conversation around security from the outset. And what we will freely make availability is our security trust and assurance pack, so that the security team on the customer side has an opportunity to go through and look at all of our accreditation, SOC 1, SOC 2, and all, so to give them that peace of mind that we're adhering to those stringent security measures that are set out across the world globally.
There is a question on digital signatures on other documents than contracts, like minutes of board meetings or shareholder meetings. Will the court accept these documents and recognize the appointment of new directors based on digital signatures on the minutes of shareholders' meetings, shareholders' decision? I don't know how it is in the Netherlands, Berend, and I would be interested in hearing your point of view. As a general message, of course, I can say any document can be signed using an electronic signature, so not only contracts, but also letters or all types of documents, with some exceptions. And when it comes to under Belgian law, I would be reluctant to say that this can be validly signed with an electronic signature, because the appointment of a director, for example, in a shareholders meeting, needs to be registered in the commercial court, and that would be considered a document that has a link with public authorities, with public registration. And I would say, according to Belgian law, this would fall under, I would say, the same category as, for example, the deeds with the notary, etc. That would still need to be manually signed. But maybe in the Netherlands, you are a bit more evolved in the digital world, Berend.
Well, you'll be surprised, Hugo. I'm not a corporate lawyer, so it's not my area of expertise, but we are having discussions now, actually, for a client with the Chambers of Commerce. In the Netherlands, we have various Chambers of Commerce in Amsterdam, Rotterdam, Utrecht, etc. And some of them, they accept digital signatures for the provision of documents, and others don't. And that actually shows, let's say, the discussions that you can have, but it also shows that back in the days, and that's not so long ago, this was all done manually with manual signatures, with wet signatures. But especially if you're a large company processing a lot of transactions or changes with the Chambers of Commerce, doing that digitally can really make a difference. And it's good to see that Chambers of Commerce is, some of them at least, most of them are open to such a change. But it still is, the corporate world is still maybe somewhat reluctant and more focused on the manual process and wet signatures, compared to, for example, commercial contracting, which is nowadays very digitalized. And you see, I would say you see more electronic signatures nowadays than you would wet signatures. Could also be my area of business. But I think that also applies to you, Hugo.
Yeah, indeed. I would say when it comes to courts, when it comes to public authorities, but also when it comes to banking, because I saw a question regarding electronic signatures with banks. Banks are obviously also very reluctant to use electronic signatures and often insist on manual signatures, or maybe even physical presence of people in the bank in order to perform certain actions. So there are domains, I would say, where electronic signatures are still avoided. There is a question, I'm not gonna answer in detail, but at Hugo addressed at me, so I'm taking it. What about the cost of implementation and the cost of use afterwards? What I want to say is, of course, I mean, it's business information, but the cost of implementation is very low. Everybody has already a computer in the office. Everybody, or most people, have a mobile phone. So implementing an electronic signature tool, what you need is a valid email address, possibly, if you want an advanced electronic signature, a valid mobile phone number. And then if you want to have a qualified e-signature, other tools in order to validate that, but that's a very limited cost, I would say, additional cost to your organization. And the cost of use is linked to the envelopes, and it's in the same way as 50 years ago when we all sent letters. We needed to post them, we needed to put a stamp on it, and in a similar way, I would say there is a cost linked to an envelope. The more you use DocuSign, the more you will pay, which is normal, of course. And then everything else depends on, I would say, the negotiation of the company and and the electronic solution providers. So nothing more to add. I don't know if there are other questions which anybody would like to answer.
We're nearing the end of time. I'd be happy to maybe choose one or two, probably we can squeeze in, and then we're going to have to wrap up the session. Is there any ones that you'd like to answer? I'm happy to choose. Well, we've got a question here. It says, is it common practice here in Singapore to witnesses sign next to the authorized rep's signature? If authorized reps sign via DocuSign, how can the witnessing part be addressed as well? If anyone wants to take that one.
Parveen,
I was about to say.
Yeah. If we want to, we can take that offline and we can follow up with a full
yeah, absolutely,
full correct answer to that particular question.
Okay. Well, this is a good time for me to remind the viewers that, of course, we've just been overwhelmed by the amount of questions, which is a great problem to have. I think none of the panelists are complaining, but of course, it is impossible to answer every single one of them. But if there is something that you do want answered, please reach out. You can either reach out to the panelists, DocuSign, Legal 500, and we can definitely get those questions of yours answered. In terms of the session, just reminding everyone that it has been recorded. I know we've been through quite a lot of detail that many of the viewers might actually want to refer back to. So just letting you know that it's all being filmed and it will be released on the Legal 500 on-demand platform in a couple of days. A very special thank you to the panelists for taking time out of their day to share their expertise. By the amount of questions and the attendees, we can certainly see this is an area that's generating not only interest, but it is something that is picking up globally. So with that being said, thank you to everyone and enjoy the rest of your day.